on, and I'll let you fix one more time.
Okay, James Powell. Mr. Haynes, you represent him?
Yes, Your Honor. Just what I'm talking to.
Okay, Mr. Powell, you're here on charges of attempted first-degree murder with a firearm, 2 counts. And Mr. Haynes, do you wish to be heard on probable cause or bond?
Yeah, I wish to be heard at this time on probable cause, and later we'll address the issue of bond through an author hearing. I haven't been provided anything new. I just asked the state, was there anything other than what they provided at juvenile, and they told me no. If I may approach the court or provide this to the court right quick. It's a case law I'm about to argue against PC.
For probable cause?
Yes.
Okay, I'd appreciate having that ahead of time for an on-the-spot decision. My office has been hearing from your office since first thing this morning. So
that's correct, Your Honor.
I'm not going to hold everybody up to read your case law. You can summarize it.
Yes, that's fine. And had I gotten anything new, which I was expecting, and I didn't, then I would have provided that to you. But nevertheless, Your Honor, based upon the information that was provided to us at the first appearance in this juvenile case, the essential facts of this case is that there was a shooting that followed contemporaneous with or a short time after a violent altercation. There was a violent altercation that resulted in gunshots. Based upon that, there's absolutely no evidence for premeditation at all in order to support the first-degree attempted murder charge. Notwithstanding whether or not this occurred, on this individual's property or not, there's nothing in the affidavit that says that it was. However, you can look at the affidavit and it's determined that the shooting happened at or near where the vehicle was parked. And so therefore that might call into question that aspect. We all know under Florida law that a homeowner has a right to use reasonable force to eject a trespasser. We also know, based on the Dorsey decision, that a overreaction to the use of force is not only not first-degree murder, it's not even second-degree. In Dorsey, on appeal, it came back that the facts supported a charge of manslaughter. While there hasn't probable cause found for the second-degree attempted murder, we don't believe that there is sufficient evidence to support that first-degree attempted murder on both counts. So we ask this court to find no probable cause as to the first-degree attempted murder.
Okay, thank you, counsel. Mr. Sullivan, how do you respond?
Judge, just referring to the probable cause affidavit, just to respond directly to that, you can look at line 33, the second page of narrative. There's easily discernible information there that talks about there's an altercation, must be some break in time where the defendant's alleged to have said, you don't know who you're directly to the person who ended up shooting, I will kill you, and then went on to shoot not just the victim who was hit in this case, but fired the gun at others later. So there is, I believe you can conclude there's a little bit of time, a thought process, and an action. So I think there's more than enough evidence, even in the 707, without regard to some of the other documents in this case file. Whether or not Mr. Haynes has been supplied with those or not, I have no idea what he got in juvenile. He's welcome to look at my file right now. But there's other supplemental reports and things like that in this case already. But the 707 illustrates probable cause for that right there.
Okay, Mr. Haynes, last word.
Well, I'll take him up on his offer again. I've been asking.
Well, I'm not protracting this hearing.
No, that's fine. Okay. I'll stand on that. When he said there was a sufficient amount of time, if you read it, it was all contemporaneous. Assuming that he actually said these statements, it still had to do with it happened after the violent altercation, which is squarely on point with the Dorsey case that I provided.
Okay, I respectfully disagree, and do find probable cause on both charges. And set the bond at none for protection of the public.
Thank you, Your Honor. At this time, we would request, based upon the fact this is his first appearance, a copy of the, I guess, documents that were being relied upon that have been filed, assumingly, with the court. I haven't even received the information.
Okay, I'm relying on this 707, 4 corners of this document. So they're right here. They'll be with the entire court file. You can ask Madam Clerk for copies as appropriate. There's also ordering no contact with Joel Tatro. That means no contact directly or indirectly. And also no weapons, firearms, or ammunition.